Hi, so what we are now going to look at is the liability for trespassers, and this is under the Occupiers Liability Act 1984. Okay, the first point, and this is A01, so this is factual content. The first point is who is an occupier. Just like under the 1957 Act, an occupier is someone in possession and control of the premises, and that is the case of wheat. The second point is what are premises? So again, a similar definition to lawful visitors. Premises, you can say they include fixed and movable structures. It's quite a wide term. It does include lakes, and that's the case of Tomlinson. Then, as a third point, I would say, who is a trespasser? Well, a trespasser is somebody who has no permission to be on the property, or they do have permission to be on the property, but they go beyond their permission. Think back to burglary when somebody exceeds their permission of what they are allowed to do. Okay, so that's the first 3 points. Who is an occupier? What are premises? And who is a trespasser? Okay, point number 4, the 1972 case of Harrington said that occupiers do owe a duty of care to trespassers. Now, after this case, the Law Commission reviewed the law and Parliament created the Occupiers Liability Act 1984. So this is what you need to know. Now, Section 1A of the Occupiers Liability Act states that a duty applies to trespassers for injury on the premises by reason of any danger due to the state of the premises or things done or omitted to be done on them. Now that sounds quite complicated. You might have to listen to that again. However, we are hopefully going to split it into like manageable sections. And if anybody wants any of my booklets, please just put a comment below. If you're not, if I don't teach you, I'm happy to email you things. So please, feel free to do that. Okay, so the next point, an occupier will only owe a duty under section 1(3) if A, they are aware of the danger or have reasonable grounds to believe it exists. B, they know or have reasonable grounds to believe that the other is in the vicinity of danger or may come into the vicinity of danger. And C, the risk is one against which they may be expected to offer some protection. And then section 1(4, the occupier must take such care as is reasonable. So again, you don't have to make sure that your property is completely safe against trespassers. Okay, so we're going to go through some cases that you can add to those points. So adult trespassers we're looking at to start off with. Case of Ratcliffe, the occupier is not liable if there is an obvious danger, and jumping into a swimming pool at night or diving into a swimming pool at night, there is an obvious danger. So you are not liable if the trespasser is injured by an obvious danger. Now, the next thing the case of Folkestone Properties said is the time of day and year is relevant. So this was somebody in the middle of the night and at winter time, and they slipped on a grid pile near on the beach, I guess, and the Court of Appeals said there was no duty of care owed to this trespasser because you wouldn't expect somebody to be there at midnight, and definitely not in the winter time. Okay, and then the case of Tomlinson, this is our one that involves a lake. House of Lords were quite strict, and they said a trespasser has to take some responsibility for their actions, and this person ignored the warning signs. We'll come back to warning signs. And they also said that an occupier does not have to spend a lot of money in making premises safe from obvious dangers. Case of Higgs said that occupier will not be liable if they don't have any reason to suspect the presence of a trespasser. Okay, so if you don't believe somebody is likely to trespass or in the vicinity, then you don't owe them a duty of care. And that's backed up by the case of Rind, where the occupier didn't know that there was a container in the lake and there were warning signs not to swim. Somebody swam and injured themselves, and they basically said, well, the occupier is not liable because they were not aware of the danger and they had no reason to suspect that it would exist. Okay, so quite a few cases there. Now, when you're looking at child trespassers, again, the same rules apply to children as they do to adults, and you've got a couple of cases that back this up. Coventry Healthcare NHS Trust, an occupier, the 11-year-old climbed a fire escape and fell, and there was no danger due to the state of the premises, which was the fire escape. So the Court of Appeal said the child appreciated the danger, the state of the premises were not at fault. So that's something to remember. If the state of the premises are not dangerous or at fault, there is no liability. And then the case of Baldacchino, again, no duty to warn against obvious dangers, so the injuries were not from the state of the premises. Okay, so in terms of the claimant, what they are seeking are remedies, so you can just very briefly point that out, that you're seeking pecuniary damages, so that's when you can put a specific amount, like I had to miss 2 weeks off work, so this is the amount of money I lost. And then non-pecuniary damages, which are damages for your pain and suffering, and they can be a lump sum or they can be structured. Now, the defendant is going to want to have some defences. One of the defences is contributory negligence. You can mention the case of Froome, which was somebody not wearing a seatbelt in a car crash. So contributory negligence will reduce the amount of damages that are available to the claimant. The other big one that's very important with trespassers and occupiers liability are warnings. So that comes under section 1(5) of the Occupiers Liability Act 1984, and also the case of Tomlinson backs it up. So if there are clear warning signs, then the occupier is not liable. And equally under section 1(6) of the same act, there's no duty of care if the trespasser consents or they accept the risk. Okay, so quite a few cases there. However, what you've probably noticed is the claimant is not successful. The courts are very strict about allowing a trespasser to win a case for damages when they have trespassed. Okay, so I hope that helps a little bit and structures it for you. There will be an AO3 video, which is evaluation.